party should be legislative party.
So if suppose, okay, political party, opposition, majority, call the leader of opposition, opposition appointed. If suppose the opposition party is less than the majority of the independents, then what will happen? Less than the majority of the independent, what will happen?
Yes, but in that case, the speaker's discretion, that the expansion, I tell you, lordship, 10% of the seat should be occupied by the, otherwise leader of the opposition is not.
Correct, 10%.
If this is below than 30%, here is a what, 294, that means 30.
30.
30, if it is not 30, then nobody will be leader of the opposition.
Correct.
In 17th Lok Sabha, there was no leader of the opposition because Congress did not reach to that 59, 544,
55,
56. Did not get in. Adit Chaudhary was not made leader of the opposition. Party's leader. Similarly, in 2006, All India Trinamool Congress got 29 seats. Initially, they did not receive the status of the opposition leader. But once Mr. Saugato Rai won from the Bonga Assembly constituency, then it became 30. Then Partha Chatterjee was recognized as the person. Therefore, the answer, the question queries, but there cannot be, below 30 cannot be in West Bengal.
Because the percentage has to be maintained.
Yes, yes. That
percentage has to be maintained.
That is the numerical strength. And here is 80. Now, they have kindly read this, below. Then, B. If he abstains from voting in such contrary to any direction issued by the political party to which belongs or by any person or authority authorized by in this behalf without obtaining in either case the prior permission of such political person or such voting and absence has not been condoned by such political party, person or authority within 15 days from the date. An elected member of a house shall be deemed to belong to the political party, if any, by which he was set up a candidate for election as such member. A nominated member of a house shall sworn, it is not required. Then, 2. An elected member of the house has been elected as such, otherwise then as a candidate set up by it is also not. He is not required. Now, 4. Notwithstanding anything contained in the following paragraph, this paragraph, a person who on the commencement of the constitution, that is also not required. Come to Miller. 4. Disqualification on ground of
defection
not to apply in cases of merger. A member of the house shall not be disqualified under subparagraph 1 of paragraph 2, where his original political party merges with any political party, and he claims that he and any other members of his original political party, A, have become members of such other also as the case may be of a new political party formed by such merger, or have not accepted the merger and opted for function as a separate group. Then group comes in, Miller, only when in a case they refuses to merge.
Yes.
Is a group,
correct.
Not a political party.
Group.
Correct. Then he remain with a group.
Because
then come.
Original political party merges with.
Suppose my party has been merged with a national political party. Yes. I am not willing to go. Then I will remain as a group, not even a party.
So then they will be their legislative party?
No legislative party. I am alone. What would be legislative party?
Because he is elected member.
Group.
That
doesn't mean that every time there would be a legislative party. Independent is not a legislative party.
Okay.
I will remain as a group. That time, because my original party has been merged, I am not willing to merge.
Expelled also. Expelled. Here expelled. Here you have expelled the 2
persons. That is all right.
Correct.
Now, if 59,
correct,
on the basis of a claim of the 59,
and they are the group of your party.
They are the group of the party. I am coming. Either they can merge with any political party.
Correct.
I have no difficulties.
Correct.
Then our political party will remain. Because original party remains.
Let that remain.
If you merge, you may merge with the BJP, you may merge with the INC, you may merge with the any other political party. But you have not merged. That can you see, read this one. Have not accepted the merger and opted to function. Have not, and from time to time, such mergers, such other political party or new political party, as the case may be, shall be deemed to be the to which he belongs for the purpose of subparagraph 2 is original political party, he will remain. For the purpose of subparagraph 1 of this, the merger of the original political party of a member of a house shall be deemed to have taken place if and only if not less than 2/3 of the members of the legislature party concerned have agreed to such merger. There were 2/3 members of that political party can be merged. I have no difficulties. After merger, if you give him the
Whatever.
whatever the status you want to give him, make him minister, make him house leader of the house, or if join in the Congress, make him opposition leader, I don't have any objection. Therefore, my lord, kindly see everywhere the words have been employed. Why I am giving an very emphasis.
The merger of the original party.
Political party.
Merger of the original political party.
And Lord, your lordships will find everywhere the political party is. Now, whether the decision is correct or wrong. Now, first of all, the practice is that the whatever the letter has been given, you cannot, the speaker, in a indirect manner, to raise an objection. The signatures are not correct, incorrect, investigation is going on. No, it is not your business to do it.
Yes.
If anybody has forced, he will face the punishment.
Yes.
But you, the speaker, supposed to be a independent person for whom the respect is there. Honorable speaker, I always say honorable speaker. He enjoys the greatest respect. He is the guardian of the all MPs and MLAs.
Yes. So
I will show you the law. My lord, that will be the cases. First, I will show my lord the Bombay, Uttar Pradesh case. It's an important matter below. Below it is an important matter. House start হয়ে যাচ্ছে seat allotment আছে, there are seat allotments, everything is there. Room allotment has been made. My peoples are running on the lobby.
The order under challenge is not annexed.
No, what can be done? This is not.
In fact, the order, there is no prayer throwing a challenge to the order.
Do not say, Mr. Bhattacharya, it will not speak well about your function as a speaker.
let us.
Please.
Then I will. Yes.
Note next question.
2022 SCC online, about 731. I will take some time to read this. First of all, similar, paragraph 2. This proceeding has been initiated on Article 226 of the Constitution of India by the petitioner seeking twofold reliefs. A direction has been sought in the nature of mandamus commanding the respondent to stay the operation of the impugn notification dated 7th July 2022, by which the recognition of the petitioner as the leader of the proposition has been withdrawn. And a direction has also been sought in the nature of statutory. The fact is, it will take some time. The fact is that initially this Vidhan Parishad, Samajwadi, they are having the 12. Now reduced it into the 9. Therefore, leader of the opposition status will not be there. Therefore, his status has been cancelled. That has been challenged in this petition. Now, kindly see. First, I am reading it because it will help on so many grounds. Kindly come to paragraph 15. These points will be taken. These points has been answered, and if required, I will show the original judgment also. The Constitution Bench of the Apex Court consistently expounded that the judicial scrutiny regarding exercise of the legislative privilege is constricted but not altogether barred. Although there is a complete immunity from judicial review in case of irregularity of procedure, however, the same is not correct for issues relating to allegations of gross illegality or violation of a constitutional provisions. The Constitutional Bench of the Apex Court, case of a Rajaram Pal versus Honorable Speaker Lok Sabha, is a big judgment. I have put it in the
Yes.
I'll show to you, Lordship, if required. So, print is there. Principle based on a catena of decision. 431, we will summarize the principle that can be carved out from the above discussion. There, Parliament is a coordinate organ and its views to deserve deference even while its acts are amenable to judicial scrutiny. It is not that the judicial scrutiny is not applied. Then the constitutional system of government adopts absolutism and the cardinal principle of our constitution that no one came to be the sole judge of the power given under the constitution. Mere coordinate constitutional status or even the status of an exculpated constitutional function does not disentitle this court for exercising its jurisdiction of judicial review of actions which partakes the character of judicial and quasi-judicial decision. The expediency and necessity of exercise of power or privilege by the legislature are from the determination of the legislative authority, are not for determination by the courts. The judicial review of the manner of exercise of power of contempt or privilege does not mean the said jurisdiction is being usurped by the judicature. Having regard to the importance of the functions discharged by the legislature under the Constitution and the majesty and grandeur of this task, there would have always been an initial presumption that the powers, privilege, etc., have been regularly and reasonably exercised, not violating the laws of the constitutional provision. This presumption being a rebuttal one. The fact that Parliament is an august body of coordinate constitutional position does not mean that there can be no judicially standards to review exercise of its power. While the areas of power, privilege, and immunities of the legislature being exceptional and extraordinary its act, particularly relating to exercise thereof, are not to be tested on the traditional parameters of judicial review in the same manner. An ordinary administrative action would be tested and the court would confine itself to the acknowledging parameters of the judicial review, and within the judicially discoverable and manageable standard, there is no foundation to the plea that a legislative party cannot be attributed jurisdictional error. The judicature is not prevented from scrutinizing the validity of the action of the legislative trespassing on the fundamental rights conferred on the state. The broad contentions that the exercise of privilege by legislature cannot be decided against the touchstone of fundamental rights or the constitutional provision is not correct. If a citizen, whether a non-member or a member of the legislature, complains that his fundamental rights under Article 20 and 21 had been contravened, it is a duty of this court to examine the merits of the said contention, especially when the impugned action entails civil consequences. There is no basis to the claim of bar and exclusive cognizance of absolute immunity to the parliamentary proceedings in Article 101. The manner of enforcement of privilege by the legislature can result in judicial scrutiny, though subject to the restriction contained in the other constitutional provision, for example, at so and so. Can you stop for a moment? There are 3 decisions of the privilege committee which are made by the Supreme Court. State. Article 121 and Article 212(1) dispute the broad doctrine of exclusive cognizance of the legislature in England or of the internal proceedings of the House renderings. 121 Article 220 displays the broad doctrine of exclusive cognizance of the legislature in England, of exclusive cognizance of internal proceedings of the House, rendering irrelevant the case law that emanated from courts in that jurisdiction, inasmuch as the same has no application to the system of governance provided by the Constitution of India. Article 121 and Article 211 prohibit the validity of any proceeding in legislature from being called in question in a court merely on the ground of irregularity of procedure. The truth of correctness of the material will not be questioned by the court, nor will it go into the adequacy of the material or substitute its option for their own. Although the legislature as a body cannot be accused of having acted of an extraneous purpose or being actuated by caprice or malafide intention, and the court will not lightly presume about or misuse giving allowance for the fact that the legislature is the best judge of such matters. But if in a given case the allegations to such effect are made, the court may examine the validity of the said contention, the onus of the person arising being extremely heavy. The rules which the legislature has to make for regulating its procedure and the conduct of its business have to be subject to the provisions of the Constitution. The availability of the rules of procedure and conduct of business made by the legislature in the exercise of the enabling power of the Constitution is never a guarantee that they have been duly followed. The proceeding which may be tainted on account of substantive or gross illegality to be protected from judicial scrutiny. Even if some of the materials on which the action is taken is found to be irrelevant, the court would still not interfere so long as there are some relevant materials sustaining the action. An ouster clause attaching finality to a determination does ordinarily allows the power of the court to review the decision, but not on grounds of lack of jurisdiction or it being a nullity. Because such gross illegality, irrationality, violation, so and so, malafide, non-natural justice. Now, we will kindly come to, I will not give you lots of trouble much.
Para 18.
The question would be whether the petitioner, by filing the present petition, has questioned any irregularity or procedure or has alleged any violation of paragraph 18. Paragraph provision. Apparently, the petitioner has challenged the include notification date 7th July, not only on the grounds of irregularity but also on the ground of violation of principal justice and jurisdiction of the chairman, speaker, and this answer. We have kindly come to paragraph 17. Kindly read. From the aforesaid pronouncement as also the constitutional provision, it is crystal clear that the exercise of any power or privilege by the Legislative Council is immune to the extent as indicated in Article 212(1). That is to say, the court will decline to interfere if the grievance of brought before it is restricted to allegations of irregularity of procedure. However, in case there is an allegation of gross illegality, violation of constitutional provision, the power and judicial shall not be barred by Article 212 of the Constitution of India. Now we can kindly come to paragraph 21. There, Parliament has introduced the, kindly see, as far as the Indian Parliament is concerned, post-independence, the concept of the opposition took root in 1969 after the split of the Indian National Congress. And I'm sure seeing the leader of the Indian National Congress was degraded as the leader of the opposition. However, it was only in 1977. With the passage of the Salary and Allowance of Leaders in Opposition in Parliament Act 19, the position of the leader of the came to be formally recognized along with certain emoluments and parts. Having said so, it is to be noted neither the Constitution nor the rules of procedure and conduct of Indian Lok Sabha or the Rajya Sabha make any provisions or provide for any procedure for appointment of leader. Even the Act provides for the service to answer. Well, this is now we will kindly come to paragraph. Kindly come to paragraph. Paragraph 37 I should read for this matter. See, the Honorable Apex Court in the case of Khito Khullan versus Jesus so and so, paragraph 37. Although answering to the adjudicative function vested in the Speaker's chairman, under the anti-defection law held that the Speaker's chairman holds a pivotal position in the scheme so and so, but that is there. But the important line which I want to show to your Lordship is this. Kindly come to Milord, next page. See, Milord, second paragraph. The Speaker represents the House. What's you got it?
Page.
Next page is page 16.
Yes, the Speaker.
Got it, Milord?
Yes.
Second paragraph.
Yes.
The Speaker represents the House. He represents the dignity of the House, the freedom of the House, and because the House represents the nation in a particular way. Here, the state. The Speaker becomes a symbol of the nation's freedom
And liberty.
Therefore, it is right that that should be an honored position, a free position, and should be occupied always by a man of outstanding ability and impartiality. Now, let kindly come to paragraph 39. Thus, in the considered view of this court, whenever the Speaker recognizes any person as a leader of the opposition, he does so on the basis of the precedent or practice of the legislature in question. Keeping in view at the same time the definition of the act, if the basis of recognition is not only in question but the practice prevailing them, he has to follow.
The practice of recognizing.
Practice and precedent. And practice and precedent, Miller, I have already pleaded to your lords. This is the practice. National party, original party has informed you. Practice is this. You cannot go beyond the practice, the precedents. But he has gone beyond the practice and the precedents.
Yes.
Now, Miller, I will show to your lordship a judgment. That is 2024, 2 SCC, page 719. চিন্তা নেই, তুই কল করবি। আজকে আমি তোকে বলেছি, তোকে আজকে বলতে হবে, তুই শুনে লিখে যা। 2024 7 SCC. I am cooperating with Mr. Bhattacharya. Never he understands. Well, this is 5 judges bench judgment 2024 volume 2 SCC, page 719. Subhash Desai versus Principal Secretary, Governor of Maharashtra and others.
চন্দ্রচূড় সাহেব একটা
শিবসেনা।
কত জানিস, আমি কিছুই জানি না।
আপনার থেকে শেখা।
Kindly come to plot. First is paragraph 106 at page 788. Almost that judgment, Allahabad judgment I have cited, and this judgment will give the answer to all of my queries. The petitioner contends that the whip and the leader must be appointed by the political party because para 2(1)b requires that the direction to vote in a particular manner in the house must be from the political party or a person authorized by it, meaning the political party. Why the leader of the opposition? What is the work of the chief whip? Leader of the opposition will decide in terms of the party's view. And who is the chief whip? Chief whip is implementing person in the house itself. Then what is important? Important is the decision of the political party, not the decision of any other individual. The respondents submit that the distinction between political party and registrable is artificial and they are intertwined concepts. For this purpose, reference was made to para 4(2) of 10th schedule and para 6(a) of symbol order. The term political party is not defined in the 10th schedule. However, the expression to paragraph 2 creates a deeming fiction while referring to political parties. The expression to paragraph 2 provides that an elected member of a house shall be deemed to belong to the political party by which they were set up as a candidate for election. For paragraph 4 creates another deeming fiction. The provision provides that if the original political party merges with another political party and they become member of such other political party or a new political party, then such other political party or the new political party shall be deemed to the political party or the members of the party. Paragraph 2 to illustrate MSJ belonging to a party. It shall not be disqualified for voting as a direction of party if a party A merges with the party B to form a party C or a party A is subsumed by party. This is because for the purpose of the 10th schedule, party B or party C shall be tuned to the original political party. Then 107, Malad, that merger, I have said so, 108,
109.
leave aside 100, and then come to 109. Political party and legislative party cannot be conflated. Kindly see. The contention of the respondent that political party and legislative party is inextricably intertwined is erroneous for the following reasons. In its constitutional capacity was a concept of the necessity of allowing any anti-defections laws to stifle inter-party dissent and freedom of expression of legislature. It was with the objectives that the defenses of merger and split which was later omitted were introduced. The 10th schedule confers legal legitimacy of the actions of the legislature which would otherwise lead to disqualification if a substantial number of legislature, 2/3 in the case of merger and 1/3 in the case of the erstwhile provision for a speech disagree with the political party. The 10th schedule recognizes the independent existence of the legislature party to the limited extent of presenting a defense to the actions of the legislature which otherwise have amounted to a defection. 111.2, Section 29A of the Representative of Peoples Act 1951 requires an association of individuals calling itself a political party to be registered with the ECI. The party need not have returned candidates to the assembly to be registered as political party. Similar, a political party receives recognition of a state party or national party based on the total number of candidates returned to the assembly by the so and so. The purpose of the recommended is not much written regard. Then literal and purposive interpretation of the provision of the 10th schedule, 1986 rules and 1956 Act. Now, these are it is given and not much required. Now, let kindly come to 113. The term whip is defined in 1956 Act. Section 2 of the 1956 Act provides that an MLA shall not be disqualified for holding the office stipulated schedule so and so. When the office of the chief whip or whip in the Maharashtra, the explanation to the clause defines a whip as follows. Now, let kindly come to 114.1. Para 2 1B of the 10th schedule provides that direction to vote or abstain from voting must be issued by the political party or by any persons authorized by it. With the word if referring to the political party, the provision states that prior permission must have been received from the political party if the member wants to vote contrary to the direction issued, and the political party must condone such action with the 15th. The provisions of the 10th schedule stipulates an unequivocal terms. The direction must come from the political party and not the legislature party. Therefore, what is it here? Dispute here is the political party's decision is not accepted. 59% of MLA of the legislature party is accepted.
Accepted or not, I don't know.
No, he is accepted. I have said so.
You have said, but you have not disclosed any order. Let
No. This is leader of the opposition is working.
Okay.
Leader of the opposition is moving with the car. Room has been given. I have said that room has been given to him.
Okay.
He is sitting in the room. He is holding conferences.
But without any order from in the web.
Order has been passed. The order has not been made published and it is not within the public domain.
Correct.
Therefore, whether this action of the speaker is also good or not, your lordships will decide.
Okay.
And I have made the opposition leader as a party here. Mr. Korn must be appearing. I know. You are always factional group and rebel group. I thought it would be the Advocate General. Why you have not accepted that?
Nobody offered.
No. He thought he will get the brief of this.
No. He is a man who will not never take any responsibility. He will only earn money. In 2011, I offered him the post of GP. He didn't accept. Later, I offered him the post of Advocate General. No, I need money. He openly said, my kids are studying in outside. I need money. He said to me, one of my good friend, very good friend, and only because of him I am staying in my house.
I think exaggeration. But I can't make him my enemy. This is one thing I make it.
Now, let kindly see. Now, the provision of the 10th schedule stipulates in unequivocal that the detection must come from the political party and not the legislature party. The distinction between political party and legislative party is made in the definition clause in para 1. There are no two ways about it. The 10th schedule would become unworkable if the term political party is read as the legislature party. A clear demarcation is made between political party and the legislature party for the purpose of merger under para 4, which stipulates that 2/3 of the members of the legislature party must have agreed to a merger of the original political party before such merger can be deemed to have taken place. To read the term political party as legislature party would be contrary to the plain language of the 10th schedule. Then, 114.2. 114.2. It is an accepted position that the whip's communication the directions of the party to its member Well, I am a chief whip from 2011. Even I am not required to take the direction from my leader of the house. I have to take the directions from my party chief.
Party chief. Yes.
And that I have to bound to implement.
Yes.
The phrase whip is neither used in the 10th schedule nor in 1982. The phrase finds a mention in 56 Act as one of the office that would not be covered with the minimum of the office of profit. The explanation to clause 23, schedule 1 to 56 are stated, chief whip as declared by the party forming the government. The reference to party in the explanation clause means political party and not legislative party because the term party is used as a depict political party in common parlance. But I was never chief whip of the ruling political party. I am always opposition. My party colleagues have become ministers, chief whip, but I am consistently from 2001, I am sitting in the opposition. One comes with the fate.
Same principle.
No, he is for earning money.
Same principle.
No, he is earning money.
Same principle.
No, he is for earning money, and I have to lose money. I have to sit for whole day when the house is going on. Now, Millard, kindly come. Ask him. To hold 119. To hold that it is the legislature party which appoints whip would be to serve the the figurative umbilical cord which connects a member of the house to the political party. It would mean the legislature could rely on the political party for the purpose of setting them for election, that their campaigns would be based on the strength and weakness of the political party and its promise and politics, that they could appeal to the voters on the basis of their affiliation with the party, but that they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs, which is no longer owes even him in allegiance to political. This is not the system of governance that is enforced by the Constitution. In fact, the 10th schedule guards against precisely this outcome. Now, see, can I read again? Sorry, Miller. They could appeal to the voters on the basis of the affiliation with the party, but they can later disconnect themselves entirely from that very party and be able to function as a group of MLAs which no longer owes even a hint of allegiance to the political party. This is not the system of governance which has been done here. This is not the system of governance that is envisaged by the Constitution. In fact, the 10th schedule guards against precisely this outcome. The speaker practically worked on the basis of 59 MLA's signature. This is guarded by the 10th schedule.
Yes.
Next, Millard, 120. That a whip appointed by the political party is crucial for the sustenance of the 10th schedule. The entire structure of the 10th schedule, which is built on political parties, would crumble if the requirement is not complied with. It would render the provisions of the 10th schedule odious and have wider ramification for the democratic fabric of this country. Such an important thing.
Yes.
Thus, the courts cannot be excluded by Article 212 from inquiring into the validity of the action of the speaker, recognizing the whip. Here, both leader of the opposition and the whip.
Yes.
Then Millard, kindly come to paragraph 127? 125. The speaker was aware of the two factions in the legislative party on 3/7/22. He appointed a new whip and new leader because the resolution of the respondent specifically mentioned that a split had occurred due to prevailing dissatisfaction in some MLAs of the Shiv Sena. The fact that there are two resolutions appointed to different whips and two different leaders would no doubt have resulted in the speaker inferring there are two factions of the Shiv Sena. The speaker, on taking cognizance of the resolution passed by the faction of the SSLP led by Mr. Shinde, did not attempt to identify which of the two persons who are nominated, Mr. Prabhu and Mr. Goswansu, or authorized by the political party. In a contentious situation such as this, speaker should have conducted an independent arrest on the rules and regulations of the political party to identify the whip authorized by the Shiv Sena political party. Inquiry is limited. Inquiry is whether the party has given you or not. Inquiry is not too wide to inquire whether signature is correct or signature is incorrect, or to determine the numerical strength. The decision of the speaker recognizing Mr. Swanswa as the chief of civil is illegal, because the recognition was based on the resolution of fractions of the SSLP without undertaking an exercise to determine if it was a decision of the political party. Therefore, what is his inquiry? Inquiry is whether it is a political party has done it or not.
Yes.
Then Rule 2F defines leader in relation to legislative party as a member of the party chosen by it as leader. The term party is ambiguous as it is not preceded by the political legislature. It may be interpreted to mean legislature because the definition clause because a leader in relation to legislature and then proceeds to use the phrase party. Or it could also be the meaning of the political party because party in common parlance means political party. Under paragraph 81B of the 10th schedule and rule 3 sub-rule 5 of the 90th, the leader of the legislature party is required to inform the speaker if the political party condone the Prohibitory Act paragraph 1(1). Thus, the leader of the legislature party is a link between the political party and the legislature party. Kindly see, my lord. The leader of the opposition is a link, and party is saying no link. I have formed a group, I am the opposition leader. No connection with the political party. Leader of the legislative party is the link between the political party and the legislative assembly. If the interpretation of the respondent is accepted, the actions of the leader condoning the MLS political conduct would not reflect the voice of the political party and would instead reflect the voice of the legislative party. This would be contrary to the manner in which the 10th schedule is intended to operate. Therefore, whole action of the speaker is subject, only object is to frustrate the 10th schedule. The manner in which the 10th schedule would then operate would not effectively prevent or provide a solution to the constitutional sin of defection. Then will kindly come, paragraph 130. The speaker must recognize the whip and the leader who are duly authorized by the political party with reference to the provisions of the party constitution after condemning in the regard and keeping with the principle discussed in this judgment. However, he is, my lord, why my submission would be before the lordship is this. He is bound to accept. But 3 times he has been informed. It was not his arena of business who has signed or who has not signed. It is not arena of business who are the numerical states saying who are the higher, who are the lower. If someone has forged any signature, that will be, she will be faced the appropriate consequences. But keeping it due, it is pending. All of us up to 2nd June, the document, or even the last document, can you read the last document? This is simple, clear, page 99. Page 99, document. Page 99.
Yes.
This is 1st June. And I have shown to your lordship, it was given on 2nd June.
When the speaker was appointed?
3rd June. The speaker was appointed on 15th.
And leader of LOP?
Now, my submission,
Opposition?
I am just coming. Leader of the opposition has been appointed on 3rd June. But my submission would be before your lordship. The speaker himself has accepted Shobhandev Chattopadhyay as leader of the opposition.
Correct.
Because both Shobhandev Chattopadhyay and the chief minister spotted the speaker, and in welcome address, speaker has directed the Shobhandev Chattopadhyay as.
Yes.
Now, meetings have been short for nothing has been given. Now, I have said below in here, paragraph that on 2nd video and etc. email, all everything was sent on 2nd June. ভাই প্যারাগ্রাফটা বলো না ভাই। Paragraph 21 kindly come. Sorry, Millard, I am repeating.
Yes, you pointed out that.
Everything has been done.
Yes.
Then on 3rd June, he has get therefore, Millard, the law which I have said, that is completely contrary to that. It is not a procedural mistake. It is not illegal, irregular. It is an illegal. Goes. Millard, another important fact is this, that these 2 persons were expelled from the party. If these 2 persons were expelled from the party, this order has not been challenged. The order exists. No one can question this order, even the speaker can question. If these 2 persons have been expelled from the party, how the speaker can recognize him as the leader of the opposition?
Yes.
Leader of that party.
Leader of the opposition. বোঝ দাঁড়া না, বড্ড কথা বলিস তোর, না বুঝে শুনে একটা কথা বলতে হয় বলে দিস। As the leader of the opposition. Madam, kindly see, in a democratic state and a democratic country, I'm just finished. The parliament and the legislative assembly is the foundation of our democracy.
Correct.
It is one of the pillars of the democracy. It is a democratic house.
Yes.
Here 2 voices will come, my lord.
Yes.
One voice from the government, another voice from the opposition.
Opposition.
Opposition speaks about the government's and my party, this party is in the opposition.
As a political party.
As a political party, 80 numbers I have got it.
Okay.
Therefore, this is gone to the very root of the democracy. Question therefore arises, my lord. Although not stipulated anywhere, whether this action hits the basic structure of the constitution or not. In a basic structure of the constitution, parliament and the assembly has the role to play.
Yes.
If you cannot change the mandate of the people, you cannot say he will be the chief minister or chief minister, numerical string. Similar principle would be applicable. Who will be the chief minister that the party will speak? Milord, in case, just I'm giving an illustration, Milord. In case the governor or the president, either prime minister or the chief minister, does not accept the party's view, and someone comes with that see, I am having majority members, then you put his name is there.
Correct.
Establish your confidence. These are the cases. But in case of leader of the opposition, it is not there.
Because it is a political party as per you.
What if party will be? Therefore, my lord, I am humbly submitting to your lordship, they kindly stay this decision. Stay the decision immediately, my lord. Matter was, my lord, it was opened on, book was opened on 8th. 9th, we have taken the leave. No? 8th, we have taken the leave from your lordship. And your lordship directed the matter would come up 11th. From 18th June, my lord, the house will begin. Number 2, my lord, there are so many things. Speaker will allot the seats. Allocation will be also naturally according to their choice. Party's choice has to be reflected. These are my all submissions. My lord, I am deeply obliged that your lordships have given me here.
Thank you. Yes.
Not only one thing, my lord, that I will indicate. But since, my lord, this is not a public interest litigation,